Welcome, everyone, to the legal panel. Today, we are blessed to have with us two of the leading world experts in litigating parental alienation cases. We have 12 questions to tee up that will cover a broad range of situations. Ashish, as a lawyer, how do you recognize that a case has elements of parental alienation?
Thank you, Colleen. First of all, it's a pleasure to be here with you and Robert. It's important to screen a case of parental alienation. And one of the side effects of more and more courts acknowledging alienation these days is that everyone wants to call a case of high conflict case as a case of parental alienation. And there's a difference there. So typically you would look at the common red flags that we see in these cases. And alienation is a spectrum. So you might have a case of mild, moderate, or severe alienation. But before you call it alienation, before you call a particular dynamic as an alienation case, it's important to look at a case very carefully and to ensure that the child's reaction or the rejection of the targeted parent or the rejected parent is vastly disproportionate to what that parent is alleged to have done. So we first look at the magnitude of the child's reaction or rejection of the parent. And then we look at the surrounding factors. Is the parent who is being rejected, has that parent engaged in any severely abusive behavior? Are there any findings, not just allegations, but findings of abusive behavior or gross neglect? How was the relationship between that child and the parent who's being rejected prior to these problems coming up? Do we have a parent who was an involved parent, a loving parent, a normative relationship, and all of a sudden or gradually the child is now saying that the parent was never around or the parent is abusive? That's a red flag. We'd also look at what evidence do we have of alienating behaviors. Because remember, Colin, a bad parenting decision or suboptimal parenting doesn't translate into alienating behaviors. There's a difference there. So we look at the evidence of alienating behaviors. One of the common strawman arguments that is made by detractors against parental alienation is that people who advocate alienation or the theory of alienation simply assume that because a child has rejected a parent, there must be alienation. And that's not true. No bona fide expert on alienation says that. It's simply a red herring or a straw man argument cooked up to just damage the theory or to cast doubt on it. So it's important to look for alienating behaviors. And let me explain. Let's say you have a case with significant evidence of Child Protective Services investigation reports, police reports, medical reports, school counseling reports. It's important to carefully go through this reports and evidence to look at what was said by whom. Is the favored parent making statements disparaging the rejected parent in front of the child? Are there any statements in any of these reports where the favored parent, for example, says to the investigating officer that the rejected parent is dangerous, he or she is unsafe, he or she is abusive? Is there any evidence independent of those allegations of such abuse? Do we have witness statements, people who have witnessed the parent disparage the other parent in front of the child? Do we have email communication, text communications? So you look at the entire gamut of universe to figure out how strong of evidence do we have of these alienating behaviors. And last but not least, we look at the signs of alienation in the child. Is the child completely polarized? Do we see signs of any splitting in the child? For example, if the child, does the child say that the rejected parent has never done anything good in the life? Is the child completely putting the favored parent on the pedestal? Because in alienation cases, especially moderate to severe cases of alienation, you see children with a very distorted view. They see one parent as all bad and the other as all good. You see the children carrying on a campaign of denigration as well. You see absolute lack of ambivalence in rejecting a parent. I mean, these children appear to be cruel. And it's interesting that they appear to be superficially well-adjusted in other spheres of their lives. So they might get A or A pluses in school. They might be winning awards in school. They might be doing great in sports, social sphere. But so far as the rejecting parent is concerned, they treat them horribly. We see text messages that are full of cruel messages, name calling, remarkably defiant and disrespectful behavior. So you look at an entire case and then realize, and then you figure out whether it's a mild, moderate, or severe case. But it's important to realize that we are lawyers at the end of the day. We are not mental health experts. There is a certain amount of experience that you get by doing these cases that makes you more skilled than an average practitioner who doesn't do that many cases of alienation. But it's always important to have a good expert on board who can look at it from a clinical or from a forensic viewpoint as well and ensure that you're on the right track.
I see. And in the next 30 seconds, could you just maybe give us a one over the world of what are some things that we should have for evidence that should be gathered to help develop a case? We have about 30 seconds. If that's
in terms of what?
Once you recognize that it is parental alienation, just real quickly, can you tell us like what are some things, some evidence that somebody should maybe bring to their lawyer? Maybe these emails and these records. Can you just give us like some bullet points on that real quick?
Any and all evidence demonstrating the factor 4 and factor 5 of the 5-factor model, alienating behaviors of the alienating parent and the signs of alienation present in the child. Also, that is not to say they ignore the other factors, but those are the two important factors. So we are talking about police report, medical reports, CPS reports, school notes, email correspondence, text correspondence. It has to be timely. We're not looking at too much of a remote past. Certainly parent is important. Get this together to your lawyer, and then we need to sit down and look at it.
Great, thank you. Hi, Robert, how are you today?
Doing fine, how are you?
Great, thanks. So tell me, are there situations where you have advised a client to not proceed with a case in litigation or a court battle?
Sure, I'll get to that in just one second. I also want to thank both you, Colleen, and Ashish for the opportunity to work with you and the hours that went into planning and preparing for this talk. It's a privilege to be on a panel with both of you. There have been a number of instances during the course of my practice where I've recommended that a client either not file a suit or not file a suit at this particular moment. Now, of course, probably most of what we do in our practice are evaluating difficult cases that look like they're headed to the courtroom. Those are the kinds of contested cases that more times than not are coming our way, and we do end up in some court proceeding. But a couple of areas that make me suggest either not to file now or to file at some point down the road. One would be is many states, if we're dealing with a modification order, in other words, there's an order in place and it's been some time since that order has been signed by the court and we're dealing with a potential alienating situation. Is there a statute that governs that says, for example, during the first year of the time period between the signing of the order and the time that you file suit, many states have a higher burden of proof. So you have to actually show that in that 1-year period, there would be a present environment of the child would significantly impair the physical or emotional well-being of the child. Sometimes that standard is easy to meet, other times it's not. And there have been occasions certainly where I've suggested to a client, let's wait until that 1-year period passes before we go ahead and file a suit so that we don't impose a higher burden upon ourselves and make our case even more difficult than it is already. A second instance where I may tell someone not to file suit is, and again, I'm referring to a modification suit, so we've got a court order in place. There's a difference between a court order that came as a result of a contested proceeding and was signed by a judge after hearing evidence and testimony, as opposed to an agreed order where the parties are basically stipulating to the truth and veracity of the allegations in the order. Sometimes unwittingly and unknowingly at the time, people have stipulated to such harsh and difficult statements of fact that really have a very negative impact on their ability to go forward with a modification case. That's not often, but it sometimes is at such a level where I say, I'm not telling you you can't prevail, but you've really kind of already sold or given away the farm by these stipulations. And I think it's going to have a very negative impact on your ability to go forward, and let them at least cogitate over that and think about that as they decide whether to move forward or not. I think that there are other instances where a case may, as lawyers, we refer to it as just may not be right. It may not be ready. It may not be the right time to strike. And that could be because we might be dealing with the early signs of alienation. We may be dealing with a very mild case that doesn't warrant quite yet coming in with a hammer or a sledgehammer and bazookas blasting, if you will, in the courtroom to try to change the family dynamic that's in place. And that happens from time to time. And I have people who consult with me over a period of months or years, and I basically do that. I consult with them. I monitor what's happening on the ground. I listen to the very fluid facts that change from day to day and month to month. And at some point, as a lawyer, you get an internal feeling that, things may get worse, they may get better, but this does seem to be an appropriate time to strike. So that would be more of an instance where I would delay and let the facts develop a little before filing suit. I think it's very important if you go to court that you feel like you've got a reasonable chance, if not a good chance, of prevailing. And you certainly don't want to undermine your position by filing a weak case and then get a court finding that denies your relief, and that kind of stays with you for quite some time. I also think that factors that bear upon whether or not I tell a client to file suit or not is, I think it's our duty as lawyers to fully explain to the clients what a case of parental alienation is truly like, and the very many and varied levels on which such a case is going to affect them. A lot of times, in fact, most times, they hear these issues and they decide to move forward anyway. But they need to know that this is something that may play out over the course of a year or two, sometimes more in the worst cases. This is a case that might end up going upstairs on appeal if we don't get the right ruling, or the other side doesn't like the ruling, which is a very delayed and costly process. I think it's incumbent upon us as lawyers to tell and teach the prospective clients of the costs that are involved, not only the attorney's fees, expert witness fees, deposition costs, maybe psychological evaluations, et cetera. It's a quite an undertaking. And I also like to probe into the family support that person has, both immediately in the household that they live in and those around them, as to whether they're simply standing on their own, and this is going to be very difficult, or they do have a good level of support which may help them. The other area, and I know I'm probably just about out of time, is just the necessity to make sure, as Ashish touched upon, the kinds of things that you want to accumulate is, are the facts developed? Do we have evidence that meets particularly the two last factors of the 5-factor model? And oftentimes I will get an opinion of an expert witness to weigh in on the facts and determine whether we have alienation, and is this appropriate time to ask. So those are some of the scenarios in which I would tell a client to either not file or certainly hold on for a while.
So it sounds like each case has to be studied for the elements that are in it. And it sounds like that the clients need to be prepared to wait to either have the evidence, or that the case is going to be a while. through the court system. Is that?
Yeah, I think you've said that very well. Each case is unique, and they're not cookie cutter cases by any means. And some need to start yesterday, and some need to start a year or two down the road.
Thank you so much. So back to you, Ashish. As a lawyer, when you go to trial, do you carry a toolkit relating to parental alienation in your briefcase or computer?
Well, yes, my fountain pen. So as litigators, we have our standard toolkits, and essentially it's evidence. When we talk about a case of parental alienation, the standard toolkit in any case of PA is threefold: facts, science, and law. Hopefully you have fleshed out the legal issues before the trial and have started to educate the judge about how parental alienation is real, how we have case law from around the country and in your jurisdiction where you are, supporting the theory of alienation. What have the courts looked for? What have the courts found for alienation, and how they have reacted to it? So that work, what lawyers typically call motions in limine or trial briefs, should be done before the trial. Now, as to facts and science, it depends upon what kind of alienation case you are talking about. Early or mild alienation cases require more of an element of psychoeducation and less of severe interventions or sanctions for change of custody and all that. But it's all an amalgamation of these three things: science, fact, and law. It also depends, depending on the age of the child. If you have a child who is about 15 going on 16 years old, then you have a limited window of intervention. In that situation, you want to go in, as Robert put it earlier, with guns blazing, in a case of moderate to severe alienation, to get the relief that you need, because you don't have the time to sit back, try to negotiate a settlement, try to see if less interventions would work, try to put in a different, somewhat of a psychoeducational to a multimodal family intervention, which may sometimes work in mild to moderate cases. You need immediate intervention, and number one priority in this case, for these cases, is child protection. So, Colleen, it depends upon how you frame a case. When you have a case of severe alienation, it is important to frame the case as protection of the child. That we are essentially talking about child abuse. This is not about custody. It's not about getting more parenting time. It's not about the targeted parent getting more repetitive time. The number one priority in that situation is for the judge to remove the child from that toxic environment, to stop the ongoing psychological abuse. And then we figure out what is the best way to go forward here. How do you reunify? How do you ensure that it's done safely? And whether the child is at that point in time capable of living with the rejected parent. I've had cases, for example, where the rejected parent has been accused of abuse before, where there have been so many allegations, sometimes sexual abuse allegations, conducted by the protective services and law enforcement. So take a situation of, let's say we have a rejected parent who is a father, and the alienated child is a teenage daughter, 14, 15 years old. And this father has gone through several investigations where he has been accused of sexually abusing his daughter, and they have been unfounded. But even in that situation, he's going to be cautious. He might have a new family, he might have younger children, he might have a wife of a different marriage. And it's important to not just put the child with a rejected parent without a proper intervention first in place. You might have new batch of allegations, and this time the rejected parent might not be so fortunate. So you figure out all these equations before going to court and asking for relief. Sometimes I've asked for placement of the alienated child in a therapeutic boarding school to allow that gap period in between before full reunification, but to get the kid away from the alienating environment. So facts, science, and law, that's a standard toolkit. When we talk about the facts, we're talking about evidence organized in the way that judges are used to seeing in court, which means timelines, chronologies, exhibits. When we talk about science, we're talking about forensic testimony, expert testifying in the case, or if there have been evaluations done in the case beforehand, we use the favorable evidence therein. And law, as I told you, should be laid out in the trial brief to empower the judge. And what we are asking the judge to do is not something totally unique or reinventing the wheel. Lots and lots of family judges have done similar things in similar situations all around the country.
So again, I think this is probably going to be a common theme, but there is no cookie cutter answer, and you have to be prepared on many different levels to present a case.
Absolutely. I think Robert has something to add here.
Yes.
Just a quick question. Ashish, do you carry in your toolkit, whether it's on your computer or in your briefcase, so to speak, like for things like the typical Doe-Bear rules and challenges in your particular jurisdiction? Sometimes those come up in the middle of trial where there's an attack on an expert. And I always like to have those things, well briefed and in my toolkit, so to speak, ready to go rather than floundering around.
I do. Excellent point, Robert. So I like to prepare what I call points and authorities. And depending on the jurisdiction, the label may change. But I may have points and authorities for Daubert challenge or a Fry challenge in my jurisdiction. So I would have cases where testimony about alienation has been allowed and accepted by court. For example, I might have cases where courts have ordered a particular intervention program, such as, let's say, Turning Point for Families. And it's important to have these kind of resources ready and available, because a situation may arise where you have to hand it to a judge or to cite from it. Sometimes I have points and authorities prepared, asking the court to take judicial notice of some cases in their own jurisdiction where a particular phrase or term has been used. Because some alienating parents, the lawyers representing alienators, often will simply argue something that is absolutely false, has no basis in law. They might say, for example, Your Honor, this entire theory of parental alienation syndrome has been debunked. It's junk science, and we shouldn't be even talking about it. And that's a time when you say, hold on, time out. No one is talking about syndrome, first of all. Number two, the theory of alienation has been accepted in many, many, many jurisdictions, including this one. And here's a point on authorities for a document citing all the cases where this theory has been accepted in this jurisdiction. That gives you instant credibility, and it makes the judge not only sit back and listen to you more carefully, but it tells the judge that you are a prepared litigator and they can rely on you.
Nice. So excellent. So preparation, making sure that you have all of your facts in a row, making sure you can anticipate what is going to be a challenge in the courtroom. All those things go into building the case for success, it sounds like, in your toolbox.
Indeed.
Thank you. Thank you. So, Robert, how should an attorney go about preparing the targeted parent for a deposition, hearing, or trial testimony?
I'm sure, happy to answer that. It's a topic that I spoke about in much more detail on April 18th for an hour talk. So in the 5 minutes that I have, there's no way that I'm going to be able to adequately address this, but there's some key issues in terms of preparing clients, targeted parents for testimony in court or in depositions. As I said in my talk a couple of weeks ago, I think one of the key elements is preparation, preparation, preparation. Nobody was born knowing how to testify in the courtroom, let alone testify effectively in the courtroom. And I think it's the lawyer's job to sit down with the client many, many times and educate the client on both the general rules as well as the specifics of the case of how to present yourself. It starts by identifying the themes of the case and making sure that in the 5-factor model, but there's evidence and facts to support each of the 5 factors. It also goes into trying to address with the client speaking from a position referred to as personal knowledge. Oftentimes, a client may be asked in the courtroom, well, have you ever seen the alienating parent? Those aren't the words that are used. Engage in these 17 strategies? And the answer is no, personally, I haven't. That's an area that needs to be shored up and worked on, because there probably is quite a bit that has been witnessed, or at least there's other witnesses or exhibits or evidence that can be used to support that position. I think to help effective testimony in the courtroom, it's important to identify strengths and weaknesses with the targeted parent, allow them to see each point from various perspectives, not only their own, recognizing that the odds are almost 100% or astronomically high, that they've got a few issues themselves to deal with, and we need to talk about it before we get to the courtroom, how we're going to confront it. I go through a series of general rules that I talk with clients about that probably takes a couple hours to talk about fully. It involves such things as how to dress. Do not assume for a moment that your client will come appropriately dressed to the courtroom. If I had more time, I could give quite a few humorous examples of, no, I was not referring to that. And somehow that's what they picked as appropriate. So I talk about body language. I talk about eye contact. For instance, in this Zoom presentation, Colleen, if I'm looking at you, you can see where my face is. If I'm looking into the camera, I'm looking straight on, and I can't see what that looks like because I'm looking in the camera. Even if it's a Zoom trial or hearing as opposed to a live in the courtroom hearing, you want to make eye contact with the fact finder, whether it's a judge or a jury, and looking into the camera is important. I tell people a simple 4-step rule: listen to the question, make sure you've understood the question, answer that question only, and then stop. And the last 2 are the hardest. Answer that question only, and then stop. Don't speculate, don't volunteer, don't think out loud, don't be unnecessarily helpful, which would be like, well, off the top of my head, I don't know, but if I could look in my briefcase, I'd be able to find the such and such. And then, of course, a break is taken for that to happen. And the such and such is one of those things that's a dagger in the heart. and if that person had only been quiet, we wouldn't have stumbled upon it. I talked to targeted parents and clients about identifying what type of a question is being asked of you. Is it a direct question that can pretty much be answered yes, no, I don't know, I don't remember? Or is it more of an open-ended question? Why, how come, please explain, what are your reasons, give me your support, in which case you should give an answer that's kind of like a Roman numeral outline with strong, persuasive points, but not speaking in paragraphs and chapters and books, and let the lawyer pull out more questions as the examination goes on. I also place a lot of emphasis on videotaping. So I will videotape my clients over and over again before trial to run through mock direct questions, mock cross-examination questions, play it back, let the person see themselves, let them see the nervous tics and body language and poor use of speech and what they do well and what they don't do well, and try to help them improve in that regard. A couple other quick things that I would say is I tried to get my clients to visualize what it would be like to testify and to walk through the steps in their mind sort of from start to finish. People are generally terrified about testifying, and visualizing and walking through those steps is a way to reduce anxiety, and when the reality happens, it's not as bad. And then lastly, I tell clients, and again, that's a lot to summarize in a few minutes, is go see another trial. Come see one of my other trials if your case is set months down the road, where the courts are opening. That can be done more frequently live, but even on Zoom trials, most of the courts will live stream other trials, and clients will get invaluable lessons by watching that and applying it to their own case. So those would be some of the basics in that area.
Great. Thank you so much. That sounds like it is a lot of help for your clients and a lot of effort that you put into preparing them. So thank you so much for sharing that.
Sure.
So Ashish, kind of on the same line, but the question is how should an attorney go about preparing their expert witness for the deposition hearing or trial testimony?
Sure. Well, it depends upon the expert. First of all, are you using a general expert or a case-specific expert? And let me tell you what I mean by that. In some situations, lawyers use a science-only expert, which is sometimes called a general expert. Such an expert would come to the court and educate the court about the theory of alienation, the science underpinning the theory, the empirical studies that have been done on the five-factor model, the research out there that discusses about harms associated with alienation, the long-term and short-term consequences, and then thereafter interventions. What works in a mild case, what works in a moderate case, and what works in a severe case, and also what doesn't work in these situations. Such an expert usually will not have the knowledge of the facts of the case. They will not be there to testify about why alienation exists in this particular case. And then it's for the lawyer to form hypothetical questions for these experts so that the ultimate fact finder, the judge or the jury, can connect the dots at the end of the day. So with that kind of an expert, you obviously have to take care to select someone who is absolutely well-versed and familiar with the science underpinning the theory of alienation. Preferably someone who has published in that area as well. Peer-reviewed papers, books, who has testified or taught seminars before on alienation, because you are looking for someone in a professorial mode. You're looking for someone who is going to help the court understand the theory. And when you do it right, and when you have the right kind of expert for that, often what you see is a very interesting dynamic because the judge also starts asking questions. I've seen some good experts use old-fashioned, whiteboard and pen and step out of the witness chair and draw diagrams, write things on the board, and you're looking for a class. It's a seminar sort of thing. And you're looking to basically educate the court that this is real. It's a studied phenomenon. We have studies that exist to support this theory. And more importantly, we have data outcomes of the interventions and what works. So that's a general expert. And as I said, you meet someone who understands this backwards and forwards. Because you also have to think about cross-examination. The opposing side is probably going to question them about some other peer-reviewed studies or papers or books out there which have challenged the theory of alienation or have challenged some parts of it. And they need to be able to explain whether it's true, or if true, why it's not applicable to many cases, or how, even if it's true, it doesn't really matter because at the end of the day, they are not challenging the phenomenon itself, but only the application of the theory to the facts of a case. Now, on a different track, we have a case-specific expert. This is where you might be looking at, let's say, someone who has done a forensic review of the case, a record review, or someone who has done a custody evaluation of the case in the family and not only knows the science, but also knows the facts of the case. With that expert, the facts are paramount, because that expert not only has to explain what alienation is about, but also go a step further and explain to the court why it exists in this case. So with those experts, typically factor 3, which is absence of abuse and neglect, comes into the play, and it carries a great deal of weight because they have to explain that why even some questionable behaviors, despite some questionable behaviors from the targeted parent, why it's still a case of alienation. That despite so-called alleged text messages or questionable parenting or once in a while behaviors that causes someone to cringe, even those, considering even those, it's still a case of alienation and the child's reaction is vastly disproportionate. So they have to be absolutely well-versed in the facts of the case, which means they have to be familiar with the reports. As I discussed, CPS, police, medical records, statements made by the children, psychological evaluations done, if any, and be prepared to answer questions which may focus on the nitty-gritty details of the case. So at the end of the day, an expert opinion is only as good as the data it's based on. And you need to protect the foundation, because if someone can score points by pointing out that the expert was given only cherry-picked information and not the entire case information or relevant information at the very least, then you have a problem. And that's why I, for one, always like to show the bad stuff to the expert, that these are the things that you're going to be facing in cross-examination. These are some of the alleged weaknesses in this case. These are the situations where my client, the rejected parent, wasn't at his best or her best. And we need to address this.
I see. Well, thank you. Thank you so much for that. So Robert, I'm going to go to you now. Tell us what steps can be taken to persuade the other professionals in the case, such as the guardian ad litem, the amicus attorneys, and other court-appointed professionals about the merits and existence of parental alienation. That seems to come up a lot.
Colleen, that's really a good question. I think those of us that practice in this area are conditioned and used to it, but still I marvel at how many times all those people that you just mentioned, the guardian ad litem, the amicus attorney, custody evaluator, the therapist, even the judge often have some of a hostile or negative or not willing to learn attitude towards parental alienation. And I feel like almost every case, not every case, but almost every case in the courtroom dealing with parental alienation, we're starting with an uphill fight to get to the top of the hill to just demonstrate and open minds as to what alienation is and how serious it is and what horrible long-term impacts it has on children before we can even talk about remedies and the facts of the case, et cetera. I think that some of the things that Ashish was talking about regarding the things that he would keep in his toolbox or have in his toolbox are some of the ways that you can persuade these other professionals. Let me start by saying a couple of things that you shouldn't do. And I say you, meaning the attorney and also the targeted parent. It does no good to preach to these people. It does no good to talk down to these people. It does no good to ring their phone 15 times a day and hammer them with every minutia of what's happening in the case. And it does no good, particularly for the targeted parent, to act as if he or she is the expert in the area and is telling the other professionals why they don't have it right, or they're blind, or they're missing it, or what have you. All of those are almost guaranteed to fail. I like to, number one, start on a human level, which is even if there is some animosity or dislike, try as best you can as the lawyer, at least, to establish a personal relationship with those people. Be friendly, be professional, respect their opinion, listen to them, at least allow them the opportunity to speak and be heard, and don't talk over them and cut them off. Number two, provide them with some of the things that Ashish was talking about. Depending on who the audience is, it could be that you're providing them with cases from your jurisdiction that talk about where parental alienation has been accepted, recognized, certain remedies, no contact period has been supported in law. That may give some basis that this isn't just junk science and has no support in the law. I think you certainly want to provide some of the many articles that are out there that support PA, that are peer reviewed, that are from top-notch scientists and professionals. to know that it's not, again, just somebody getting on the stand and saying, this is what my opinion is. It's actually been tested and supported over decades. I think that you probably should discuss if they're focused on a negative article, a peer review article that says a PA is nonsense or garbage or has no support, through your own skills and abilities and using your own expert to be able to articulate to them what it is that's wrong, mistaken, counterintuitive, all those things to help educate them. I have done several times, I have engaged in a practice several times where I might use, like Ashish was referring to a moment ago, a general expert that's purpose is to educate the court. I might rope in some of the other professionals in the case and let them speak to that generic expert with me on the line. And I'm gently nudging and shaping some of the discussion, but let them ask their questions and let the expert explain to them. I can't tell you how many times, I'm sure Ashish has had this too, where I've come into a case. There have been occasions where I hear judges say on the open bench, not often, but sometimes, I don't believe in parental alienation. Well, that's a real tough one to start out with. Or a guardian ad litem or an amicus attorney say, I've reviewed the situation. They've been on the case maybe a week. And this is not a case of parental alienation. And I said, well, just tell me a little bit about what your understanding of parental alienation is. And it's backwards and wrong and mistaken. And clearly, this is not an expert, subspecialty person or anything like that. So you want to educate without offending. You want to provide them an understanding that this is child abuse. And certainly as a professional, would you keep your eyes and ears open long enough to see if this is happening in this case? And if it is, I'm sure as a respected professional that you would want to do everything possible to stop child abuse. So I use those kinds of tools. I'll go over the 5-factor model with them. I'll talk about the 8 manifestations and the 17 strategies. And I'll talk about the suddenness, sometimes, doesn't always happen suddenly, of a change from a positive relationship. And then all of a sudden, dad or mom got remarried and then all hell broke loose. And look at how bad it's gone. And I like what Ashish has said several times about the reaction of the child is totally out of proportion to whatever kind of negative parenting behavior or activity is being thrown at the targeted parent. Those are some of the things that I would do to help persuade the professionals in the case.
Thank you so much. Ashish, we're going to go back to you. Can you give us an idea about how long it takes to try a typical case of parental alienation?
Sure, I'll be happy to do that. But can I go a little bit back and just add to what just Robert said?
Absolutely.
I think it's Robert makes a really good point about persuading the guardians ad litem and amicus attorney, the children's attorney in these cases, even the judges. And sometimes you have to take those negative statements that they tell you with a grain of salt and just let them speak for a while and try to persuade their how they approach these cases. One of the frequent situations I find myself in about is that the attorney for children or guardians ad litem involved in these cases want to come out and say directly that they dispute the theory of alienation. They will concede that there were some bad behaviors. It does appear that one parent appears to be alienating and the other is a targeted parent, but oh well, too bad, because the kid's 16 years old and we can't really do anything that the kid doesn't want to do. And we just have to be patient and hope that situation changes. Otherwise, the kid's gonna kill himself or run away or do something drastic. And we all will be shocked and we just have to wring our hands on that. And that comes out so often that I start slowly pushing back. What I used to do early on is to just throw research in there. Have you read this paper? Have you read that paper? Look about that study. And I realized that shuts them off. They either stop responding, they don't read it, they don't engage in good faith. And in such situations, I find it important to invite someone that I'm not using in the case as an expert, but nevertheless, someone who has really good credentials and reputation as an expert in this area, and invite the guardian ad litem to join the call. Why don't we have a call with this expert? I have not used him in this case. I am not going to use him or her in this case. But here are all the articles or books written by this expert. Let's just pick their brain. But if you want to have a one-on-one call with that expert, I'll be happy to facilitate or introduce you to that expert. Let's just use a name for the sake of an argument. Let's say Dr. Baker, Amy Baker, or Richard Warshak, or Stephen Miller. And then that expert can educate the guardian ad litem, the professionals, about how this is not true. And we have data showing the exact opposite, that even 16 or 17-year-old children, when put in a specialized program, do reunify, do come back, provided certain parameters are put in place. And they connect these people with other professionals or parents who have gone through this. And that's when you start the change happening. You see the change slowly happening, because these people then get empowered. And it's important that when they put an idea before a judge, they own it. It's their idea, it's their solution, and you help them get there, but they have to own it. So back to your question to me, how long does it take? Well, every case is different. It depends upon the amount of evidence. It depends upon how many children are we talking about. It depends upon whether it's a moderate or severe case of alienation. But at the very least, I would say 6 or 7 days of trial. And Colleen, we have to understand that when we say days, often judges don't have the entire day set aside for your trial. You might have a judge who would give you a half day here or half day there, or even within the full days, they might take few emergency motion hearings. So you are really looking at a day consisting of 4 or 5 hour tops sometimes, counting the recesses and lunch and all that. And if you have a case of moderate to severe alienation and you're asking for removal of the child, change of custody, or specialized intervention, you have an uphill battle, generally speaking, to convince the court on those issues, because you are asking them to do something that is very counterintuitive. You're asking them to put the alienated child with the rejected parent, the child who has refused to go on parenting time, the child who has refused to even speak with the parent, the child who has sometimes lashed out against that parent, has engaged in violent behavior, and all sorts of things. And they are sitting back and thinking, how on earth that's going to happen? What's going to happen to me, the judge, if that kid runs away? Am I going to be in the front page of the local newspaper? Am I going to be criticized for something? So you have to help them understand the science behind it, the success studies, the intervention programs, how this doesn't really happen in all these cases, all these families that have gone through these programs, and we have data for that. And that takes time. It takes significant amount of time. So you have to have the expert testimony. And then more importantly, as Robert earlier talked about, preparing the client for the deposition. The targeted parent has to testify and ensure that the judge knows what is it to be in their shoes. What is it to be in the place or in the shoes of a targeted or rejected parent? What is it like a day in their life? When they have the kid on their hands or they have no contact, what was it like before? So you have to combine the facts and the science and then empower them with the right tools. And you can't do it in 2 or 3 days. And judges do it all the time. They often tell us, well, I only have 3 days, gentlemen, and it's up to you how to try your case. But and you have to file motion. You have to argue due process. You have to tell the court that these are constitutionally protected liberty interests, parenting and custodial rights at stake here. We have an offer of proof. We need to present this evidence, and we need more days. And they will relent. They will ultimately say, fine, we'll give you more days. You might not have consecutive days. You might have 3 days a year and 4 days, a week or 10 days after. But that's the name of the game. I have had cases, very contentious cases, lasting for like 5 or 6 months, few days here, a few days there, and the trial took that much time. Ultimately, it was worth it. So you have to put that fight up front. Sometimes when I get into a case, a local counsel will tell me, well, this judge is never going to go for it. We are going to have our heads beaten up if we go and say we need more than 4 days. It never happens here. Well, too bad. It is what it is.
I've heard, even as a mental health professional, I've heard that exact argument before as to why we're not going to be able to have that much time. We'll have a day and that's it. So I've heard that myself, and not even being a legal expert. So we have about 4 more questions, and we're going to kind of do maybe a little rapid here because we have about 20 more minutes left to our time, and I'm going to see if I can get them all in with rapid fire. So Robert, we're going to go to you. My understanding is that Texas permits jury trials for custody cases and parental alienation cases. So how is such a trial different from a bench trial? And what are the lessons from trying jury trials can be translated into bench trials?
Sure, I'll try to handle that in 4.5 minutes. It is a pleasure to try cases to juries. Texas is the only state in the union that I'm aware of that permits jury trials in child custody and parental alienation cases. And they're very, very different. There's a lot of similarities, but they're very, very different. I would say, one thing that we want to do if we have an opportunity in front of a judge or a jury is we want to give an opening statement, because an opening statement allows us to have the judge look through different lenses in viewing this case, the highly counterintuitive nature of PA cases, et cetera. And you're going to get an opening statement in a jury trial, and oftentimes you don't in a trial before a judge. Probably the most critical difference, though, is in the, we call it voir dire down here in Texas. I think Dr. Miller calls it voir dire, and probably no matter how I pronounce it, he's going to criticize me for saying it the way I did. But it's the most fascinating part of the case. You're sitting there and 60 people come into the courtroom. This is pre-COVID, although it's opening up again. And you get an hour, give or take, to walk up and down and talk to prospective jurors and ask them questions. I love the theater and the drama that goes into that. It's very, very exciting. It's a very important part of the case. And while you don't get to select your jury, you get to exclude people who are hostile to your case. So you try during that period to eliminate those that think PA, is a bunch of nonsense and couldn't possibly ever apply. And you have a much better chance of seating 12 people by having the personal interaction that you do during voir dire, as opposed to the random assignment in the particular county you're in. You land in a particular judge's court, and for good or for bad, that is the fact finder as opposed to 12 citizens. So I think that's probably the primary difference. A couple other quick things would be also, I think jury trials call for more theater, more drama, more emotion than trying a case to a judge. And having tried for 35 years cases to juries in Texas, I feel like having done that and having had to perform in front of citizens has allowed me to be a better lawyer in front of judges, because you have to do the same thing. You have to persuade, you have to speak with artful words, you have to know when to pause, excuse me, you have to know when to be dramatic and when to sit down. And all of those kinds of things that I've mentioned in this very short period of time really do help translate into a bench trial in front of a judge. I think it makes you a better advocate, makes you hopefully a better lawyer, and helps you advocate for your client even better. Lastly, it allows you to give a dramatic closing argument with evidence, with passion, with conviction, with analogies that oftentimes judges may not want to hear because they're seasoned and they've been through it. So those are some of the differences and applications to a bench trial.
Thank you so much. Ashish, we're going to go back to you. We talked about different types of experts, and what I'd really like to drill down on is, are there instances in which parental alienation cases can be tried without an expert? And what if a parent or a client simply is unable to afford the expert?
Okay, so that's a two-part question. Part one, can you try a case of alienation without an expert? You most certainly can. There are many cases where the courts have found evidence of alienation without an expert. The judges have looked at the facts, the judges look at the bad behaviors, alienating behaviors, some signs of alienation in the child, and any judge can do an analysis as to what's in the best interest of the child. So if you have that kind of evidence, which is clear cut, alienating behaviors and signs of alienation or dramatic polarization in the child, you can take it to a trial without an expert. In fact, we have had a case recently from Canada where the Court of Appeal said you don't need an expert to make a finding of alienation, trial judge. You can rule based upon the facts using the best interest model. And even in the US, we have had cases in Colorado and other places where courts have done that. Doesn't happen that frequently, that often, but does happen. The second question as to what kind of expert you should choose, was that the question? I forgot the second question.
I muted myself. The second question was, what if they can't, if they simply can't afford one, but maybe one should be had?
Well, that's a tough one. And I can certainly understand the situation. There are a lot of parents out there who simply have run out of resources or have no resources to get a top-notch expert on board. What I try to tell lawyers when they call me in the situation is to still reach out to some good expert to see, A, if they could discount their rates or sometimes testify pro bono. You know, with this advent of Zoom technology in the past 15 or 18 months, we have had all these trials remotely. And I think it's going to continue this stage where the judges are now used to allowing out-of-state professionals appear by video is going to continue for some time. And we are getting better at it. So reach out to experts and ask for help. Tell them that we have a case, we have clear-cut evidence of alienation. Would you please consider testifying at a discounted rate or on a pro bono basis? I mean, depending on the workload, depending upon where the expert is, he or she may say yes to that. One can also explore the local resources of the legal aid societies in a particular jurisdiction. Sometimes a friend of the court offices may also have limited licensed psychologists or behavioral scientists, mental health professionals working there who might be willing to take a look as well. But if you don't have resources, it's tough. You can also ask in many jurisdictions, the court to award fees to you or to apportion costs accordingly, that one party is the paying party, so to speak, or has the money and the level and the field is not level. You can ask that the fee should be advanced to you, provided so that you can get the help that you need. And depending on where the case is in a divorce situation, the courts sometimes do that to protect the best interest of the child. Some counties have their own funds, and sometimes the counties will advance funds if it is necessary to produce expert testimony in cases of child abuse.
Thank you so much, because I think those are important questions, because I know I hear that a lot from my clients too, that they're just running out of resources because these cases can last so long, as you said earlier on, Ashish. Right. So Robert, back to you. How does the fact finder's awareness and knowledge of parental alienation impact the case? And how does a lawyer's strategy need to be adjusted according to that awareness?
So that's a really good question as well. If you're trying a case in Texas to a jury, you can assume through the voir dire process that there's not a lot of awareness or knowledge about PA, and you're starting on a blank slate or with a blank slate. So you know that you've got to educate and teach quite a bit. When you're in front of a judge, to the extent that it's someone that's been on the bench quite some time, if it's in your jurisdiction, you may know the answer to these questions. If it's in another jurisdiction or out of state, we are being brought in to assist. You need to ask local counsel to get as much due diligence and intelligence on the judge to know whether or not he or she has had a case like this, whether it's ever made its way into a published opinion, whether there are any lawyers in town that have tried these kinds of cases in front of the judge. But the basic issue is you oftentimes don't really know how much a judge knows or doesn't know about parental alienation. And sometimes they'll give you a clue and say, move on, counselor, I'm aware of that. But you have to assume that they too probably don't know that much about parental alienation because there hasn't been that many cases fully fleshed out in the report that involve these details. To the extent that you feel like the judge is less aware, excuse me, the need for more expert testimony. Maybe you need both, which is the generic expert and the case-specific expert. The need to find ways and mechanisms, which would be beyond the scope of this talk, as to how to get the learned treatises and articles to the judge's attention properly in court for reading and study. To the extent that the judge appears to have knowledge and through pretrial proceedings, you learn sort of his or her bent on certain things, and that'll help you shape where you put your evidence and where you need to persuade even harder, depending on some of the things you've heard throughout the whole pretrial process. Like one quick example would be, it would be common for many judges to have a knee-jerk reaction in what appears to be a dysfunctional or severely dysfunctional family or extended family to ship one or more or all to traditional therapy, traditional counseling. And that has its place, of course, in many walks of life, but it really doesn't have much success rate in the PA arena. And that's an area where you really need to increase the judge's awareness of how traditional therapy is not going to help and is likely going to make things even worse. So in the interest of time, I think I'm going to stop talking on that point.
Oh, thank you so much. Not that you stopped talking, but thank you for the information. So we have two more questions. Ashish, I'm going to go back to you, and then Robert, we'll have you for the last question.
Okay.
So, Ashish, what are the effective techniques to persuade a skeptical trier of the fact?
Well, the single most important thing there is empowerment. You need education and empowerment. You need to educate the trier of the fact as to what is alienation, why your case has elements of parental alienation, and then empower the judge or the jury to make the right decision. I think it's a two-pronged effort. One is to show, assuming that the alienation battle has already been laid out, the judge is aware of alienation, is not a skeptic of the theory, and understand that it exists in this case. That being said, you have to lay out in detail the consequences of inaction or inappropriate or rather inadequate action here. What happens to children if no interventions are put in place? What are the short-term and long-term consequences that data tells us these children face as they grow into their adulthood? What's going to happen to the targeted parent? How does this play out across generations? So you lay that science out, and then you also tell them that not all is lost here. These cases are not all doomsday scenarios. You can save the child, you can protect the relationship, and these are the outcome studies, and these are the cases all around the country where it has been done so. And one of the common mistakes that people make, as per my opinion, is to not go back and look at some cases which are not out in their jurisdiction. So, for example, if I'm trying a case in, let's say, Illinois, I often will have a local counsel say, well, that's all well and good that the Nebraska court or New York court did that, but my judge in Chicago is never going to go for it. And I don't think that's right. I've had judges who did take a good look at a case coming out of Texas or Illinois or Nebraska, because at the end of the day, you are trying to convince a judge that here you have a fact finder, a trier of fact, similar to your position, similar to your circumstances, who wrestled with the same issues that you are wrestling with and was able to come up with a solution. Yes, that case is not binding on you, but let's take a look at what that judge did and how it worked out. That empowers them. That makes them think I can make a change. I can truly make a decision that's going to save the child. And I think that's the way to go about it.
Great, thank you so much. Robert, last question.
Okay.
What can a targeted parent do to help his or her lawyer? Like, what can they do? Like, what can they say, and who's like your ideal client?
Okay, I'll try to combine those two by first starting with the things that a targeted parent can do to help his or her lawyer. And then my ideal client would be the one that does these things I'm about to say, because most don't, and it would be great if they would. By the way, starting with how do you help your lawyer, I think the selection process is incredibly important. If you find a lawyer who may have the best heart and the best intentions, but knows nothing about PA, all and everything you give to him or her is probably not going to move the needle much unless he or she associates somebody that has expertise. So I'm assuming your question refers to a lawyer that has expertise and has knowledge in this area, and what can a targeted parent do to assist? Well,
yes,
many things. First would be evidence gathering, as Ashish has mentioned, text messages, emails, school records, medical records, therapy records, fitting into the various slots of the 5-factor model, evidence that supports each, whether it's from their testimony, another witness's testimony, or the documents, helping organize the case. Being organized, by the way, would be so helpful. I can't tell you how many clients literally come up with boxes and boxes and suitcases and containers I never could dream would hold so many papers, and dump them in our office and say, here you go. That doesn't help. It's disorganized, and it's difficult to present a case with that kind of presentation of raw data. You can help by being focused. You can help by following your lawyer's directions. You can help by having more of the 4 C's, as we say on these talks, and less of the 4 A's. The 4 C's about being calm, cool, collected, charming, which is typically the alienating parent that has that. And the 4 A's being the anxious, agitated, afraid. And all of a sudden I forgot the last one, sorry. Angry. Angry, oh my God, angry. Please do not be angry. So, I understand, and we all understand that these are very difficult situations with what's happening with your children, but the louder you scream and the more you point the finger and the more you shout, the less likely people are to listen to your message and be persuaded by you. Also, do not, unless it's absolutely essential, do not, during the pendency of the case, call the police every other week, file CPS reports, file disciplinary actions against the amicus attorney and the ad litem, guardian ad litem, file judicial complaints with judicial commissions against the judge. You look crazy when you do all of that, I'm sorry to say. And there may be a time and place for all of that, but it shouldn't be done side by side with the presentation of a persuasive, organized, educated case, if you will. So those are some of the things. There's so many other things that targeted parents can do to help, but in the interest of time and stopping on the dot, I think that's probably all I can say.
Yes, Ashish, I was going to go back to you and see if you had any other of those. We have about 6 minutes left, so go ahead. I am going to ask you guys both for a wrap up before we cut out. So
I was just going to add one more thing to what Robert said. And by the way, I completely and wholeheartedly agree with him on everything you said about a perfect client and what they can do to help their lawyer and their own cause. I would also add to what Robert mentioned, to be careful what you post on social media. We see clients who are so frustrated and so outraged as to what's going on in litigation and the help they're not getting, to go on Facebook, go on other social media platform and just lambast everyone. They badmouth the judges, they badmouth lawyers, they badmouth guardian ad litems, they post filings, court filings on social media. They talk about the children, they sometimes mention children by name, post photographs, and then people join on those conversations. They add their own stories, and it's out there. It's never going to go away. And that kind of evidence can be used against your client in cross-examination, that could devastate someone's credibility. That could completely tank your case, even if you happen to have a good case of alienation. And we have many cases where the courts refuse to grant intervention simply because the rejected parent did not have credibility. So I understand it's very painful to go through alienation, and you are very frustrated as a targeted parent, but please be careful in the evidence or your words or your statements if you ever go to social media and discuss your case. My rule of the thumb, and I tell this to every client, is to not discuss your case or anything about your situation on social media, period.
Very good advice. As a mental health provider, I can't go and look at any of my clients. However, being involved in a couple of cases, I have had the unfortunateness to see what some clients do post on their Facebooks and websites, and it's unbelievable sometimes. But yes, and it gets them not a lot of sympathy from the judge in the cases. I've seen that. So I'm going to ask both of you for a summation. From what I've heard both of you say, there is no cookie cut answer to any of this. That the cases need to be accurately and correctly assessed, and you have to be prepared. You have to be prepared for just about anything at any given time. So since we started with Ashish, Robert, we're gonna end with you. So Ashish, if you could wrap up in the next 30 seconds, kind of a summation of all this for our audience.
Well, preparation is the key. You have to be prepared to do a trial in this cases. But more than that, you have to be mentally prepared before accepting a case, because cases of parental alienation take up enormous amount of time, resources, and just your mental orientation towards it. These cases are not easy. You will have a parent who is going through a trauma, a parent who is being rejected, and you quickly have to draw boundaries as well. You have to make sure that your client understands that you are their lawyer. You are not their therapist. You are not their buddy. You need to make some ground rules, and you need to make sure you don't start giving out parenting advice. I often see lawyers get burned out or start taking the calls at all hours of day and time, and then give parenting advice about what to do and what not to do. And I think that's a slippery slope. So before you take a case of alienation, especially severe case of alienation, read the science, read the research articles, read some of the cases as to what it entails and what it's going to involve before you commit to the case.
Thank you. All right, Robert, you got the last word.
Last word in 30 seconds. I'll see what I can do. A couple random thoughts that strike me in closing. One, preparing and trying a parental alienation case is very difficult, and there certainly is a need for expertise, compassion, understanding, persuasion, many things. But it is really not for the first time lawyer, even an experienced lawyer, to try a parental alienation case without the assistance of a specialist lawyer to assist. I think it's critical. Not every case can afford it, and not every case justifies it, but it's very important to get the right help. It seems like, as I mentioned earlier, many of the professionals, even the judge, often are skeptical about the case and realize you need to roll your sleeves up to educate and try to overturn the natural assumption that the kids are rejecting the parent because of the parent's bad parenting choices or behaviors. Understand that the targeted parent is nervous, anxious, afraid, angry, and work with that client, because that client needs attention to help through this very difficult process. It's an incredibly difficult process. You need time to educate the court. You need time to thoroughly prepare your case. You need to be able to identify and anticipate the attacks that are going to be thrown against you and your client in the courtroom. You need to use expert testimony. And again, you need to associate all of the expertise and professional help that you can. These cases are difficult, but they're not impossible, and they are winnable. but it takes a lot of effort. It's really been my pleasure speaking to all of you, and I hope this talk has been helpful.
Thank you, gentlemen.